Hello everyone, I'm Akshata Halganawar. I'm going to explain the topic consideration through this presentation. Let's begin with definition of the consideration. According to section 2D of the Indian Contract Act 1872 defines consideration as when at the desire of the promisor, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or abstain from doing something. Such act or abstinence or promise is called as consideration for the promise. In general sense, consideration means something in return. For example, X promised to deliver 10 kgs of basmati rice to Y and Y promised to pay rupees 500 upon delivery. In this contract, Y's promise to rupees 500 upon delivery is the consideration for X's promise. Similarly, X's promise to deliver 10 kgs of basmati rice is the consideration for the promise Y made. Essentials of the consideration. In accordance with the section 2D, the essential features of the valid consideration are as follows. It is given at the desire of the promiser. It may move from any person. It can be past, present, or a future consideration. It must be real or possess value. It must be a illusory. It must be a something other than the promiser existing obligation. It must be lawful. First one, it is given at the desire of the promiser. The action or abstinence from action must be done at the desire of the promiser. It means if the promisee has does something or obtains from doing something at the desire of the third party or voluntarily, it is not valid consideration. The consideration has to be done at the instance of the promiser or the promise will not be able to enforce the same. For example, at the request of the collector of the district, X spent money and constructed some shops. Y, a shopkeeper who occupied one of those shops, promised to pay to X commission on the sale of goods made by him as consideration for the money X spent on the construction. X sued Y to recover the promised commission. Since X had not constructed the shops at the desire of the Y, the promiser here, there was a valid consideration as required by section 2D. Thus, the agreement was void and Y was held not liable to pay the promised amount. Second one, it may move from any person. It does not matter who furnishes the consideration. The consideration may be moved by the promise himself or any other person including. For example, X, an old woman, gave away certain immovable property to her daughter through by a registered deed. She also directed her daughter to pay an annuity to Y, the old woman's sister. The same day, the daughter executed a deed in a writing and undertook to pay annuity to Y. Subsequently, the daughter failed to pay annuity and Y brought a suit for its recovery. The daughter pleaded that she was not liable because no consideration had moved from Y. The court held that the words the promisee or any other person in section 2D made it clear that consideration need not move from the promise only and Y was entitled to maintain the suit for recovery. Third one, it can be past, present, or future consideration. Past consideration. Consideration is the price for a promise and thus it is usually given in the response to and as an inducement for a promise. If the consideration is given earlier than the date of the promise by the promiser, then it is known as past consideration. For example, X found Y's purse on the road. He returns the same to Y, who promises to give rupees 100 to X for his services. This is valid contract. Present consideration. When consideration and promise take place simultaneously, it is called present or executed consideration. For example, X goes to a shop and buys a bottle of water from there. He also pays the price on spot. Future consideration. If the consideration for promise moves after the formation of the contract, it is called as future or executory consideration. For example, X promises to deliver to 10 bags of rice to Y after 10 days, and Y promises to pay for the rice 10 days after the delivery by X. Fourth one, it must be real and possess value. It must not be illusory. Consideration must have some value in the eyes of the law. A worthless act cannot satisfy the spirit of the definition. For example, X, the wife of Y, withdrew her suit against Y in a return of the promise to pay her maintenance. It was held that it was good consideration. Fifth one, it must be something other than the promisor's existing obligation. It means performance of an existing obligation or legal duty is no consideration for a promise. For example, X receives summons to appear before court of law as a witness for Y. He is promised certain amount of money by Y for appearing in court. The promise to pay X is void because of a lack of consideration for Y, as X was already under a legal duty to appear as a witness before the court. Sixth one, it must be lawful. It means the consideration must not be unlawful or opposed to public policy. For example, X offers rupees 1000 to Y for beating up Z, his enemy. Y beats up Z, but X refuses to pay him. Y cannot recover the money promised to him because the consideration is unlawful. Thank you.